Kia ora koutou. Today we present the Making Child Support Better Bill 2025, proposing fairer, more efficient reforms to the Child Support Act 1991 to better meet the needs of tamariki and whānau in Aotearoa. In force since the 1st of July 1992, the Act sets a legal framework for assessing, collecting and enforcing child support in New Zealand. Managed by Inland Revenue, it ensures both parents contribute financially to their children's care, regardless of relationship status. Section 4 reflects a shift from viewing support solely as a parental duty to recognising children's rights, aligning with Article 27 of the UN Convention on the Rights of the Child. While only caregivers can enforce these rights, the Act uses an IRD administrative formula to uphold them. Section 4 sets 11 objectives, affirming all legal parents' shared duty to support their children according to capacity and care, carers' rights to receive support without court involvement via the IRD, fairness between parents and carers, and priority for birth/adopted children over stepchildren. Since July 2023, payments go directly to caregivers, reducing public costs while ensuring support reaches those entitled. The Act provides several ways to obtain child support. The first, a single individual may choose to support the child alone. Parents may have a private agreement, which is unenforceable outside the IRD, or a voluntary agreement enforced by the IRD, encouraging cooperation. The most common option is a formula assessment, where the IRD calculates payments using a standard formula. To initiate a formula assessment, 4 criteria must be met: a qualifying child, a liable parent, an application made, and then the formula. The formula assessment calculates child support using factors such as each parent's taxable income, care percentage, number of children, standard expenditure tables, an income cap, and a minimal threshold. The paying parent makes payments to the IRD, which then passes them to the receiving carer. Payments may be deducted from wages or made manually, and shared care can reduce liability. While intended to be objective, the formula is seen as unfair. Parents may apply to the family court for a departure order if it produces unjust results, such as in cases involving high special needs costs or unusual financial situations. Exemptions from child support are limited to cases such as long-term illness, imprisonment, being under 16 with no income, or surviving a sexual offence. Late payments incur a 2% penalty after the due date and 8% after 28 days, with a 60 grace period for new liabilities. Penalties may be written off for reasonable cause, IRD error or hardship. Inland Revenue has strong enforcement powers, including wage or bank deductions, court summons, community work for deliberate non-payment, and arrest for attempting to evade payment. In summary, New Zealand's child support system is designed to make sure children are supported by both parents in a fair and consistent way. While Inland Revenue manages most cases using a formula, parents also have options to make private arrangements or apply to the court in more complex situations. The goal is always to ensure that the best interests of the child are at the centre of any support agreement.
The current child support regime reveals several significant flaws, and as Bill Atkin observes, there is no piece of family law legislation that has generated as much hostility as the Child Support Act. The public reflects similar frustration, with some describing their experiences with child support as a nightmare or likening their interactions with Inland Revenue to dealing with Satan. It is no secret that many parents, both paying and receiving, are deeply dissatisfied with the system they are subject to. Critique 1. The first significant flaw in the current regime is the lack of accessible education for parents regarding how child support payments are calculated. Under Inland Revenue's formula assessment, parents are required to enter basic information, and the system produces an estimate of the amount payable. However, it offers no transparency around how this amount is derived. There is no breakdown of figures, explanations of the underlying formula, or insight into the reasoning behind the calculation. This leaves many parents feeling blindsided, unfairly treated, and less willing to comply with the obligations, especially if payments are high. In some cases, parents are forced to seek legal advice to better understand their child support assessments. This is neither realistic nor accessible for many, particularly those with limited financial resources. As a result, the complexity of the system can create a barrier to justice and deepen feelings of confusion and frustration. The formula assessment itself is highly technical and relies on broad assumptions based almost entirely on income. It fails to reflect the individual needs of children and families and does not account for real-life costs such as education, healthcare, or extracurricular activities. This disconnect leads many parents to view the obligations as arbitrary and impersonal. It is a standardised assessment that does not reflect the practical realities of raising a child. Critique 2. The second fundamental issue with the child support regime is the complete lack of transparency around how payments are spent. Once a payment is made, the liable parent has no visibility or control over how the funds are used. This can be particularly frustrating for those contributing significant amounts who are still expected to cover additional costs when the child is in their care. Many parents express genuine concern that their money is not always being used for the child's benefit. There is currently no requirement for the receiving parent to account for their use of the child support funds, nor are there safeguards to ensure the money is directly towards the essentials. This absence of accountability can foster distrust, frustration, and resentment within co-parenting relationships. While it may be impractical to monitor every transaction, the complete oversight creates a perception of unfairness that can seriously damage the co-parenting relationship. When a parent feels financially overextended, they may become reluctant to make additional purchases for the child during their contact time, believing they have already contributed enough. Over time, these dynamics can lead to emotional strain not only between the parents, but also between parent and child. A paying parent may grow resentment about the financial burden, while the child may perceive the parent as less generous and less interested in their needs. For a system intended to operate in the best interest of the child, this outcome is deeply concerning. Instead of fostering cooperation and support, the regime can unintentionally contribute to fractured relationships and long-term emotional harm.
In response to our first critique of the Child Support Act, we propose that before applying to IRD for a formal child support calculation, separating parents must attend mediation and complete a child support education course. This mirrors the Care of Children Act, which requires family dispute and parenting through separation courses before custody matters reach court. Similarly, our reform allows exceptions in cases where mediation is deemed inappropriate. Many parents don't realise IRD doesn't need to manage child support, or that private agreements can be legally enforceable. Our reform aims to educate parents on all aspects of the child support system and the full range of available options. Structured education could improve compliance, reduce grievances, and support better outcomes for children. It aligns caregiving and financial responsibilities and promotes a proactive, child-focused approach. In line with the Care of Children Act, our proposal includes up to 12 hours of government-subsidised mediation annually. This can include preparation time and incorporating the child's perspective. Parents could discuss finances transparently and agree on fair contributions. Specific preferences such as paying for school fees or extracurriculars and shared expenses like one school uniform across homes could be addressed. This supports inclusive conversations about extended whānau, shared costs and childcare. We propose these agreements be reviewed every 6 months through further mediation. Reviews could be opted out of with a written agreement from both parents. Once signed by parents and the mediator, agreements would be legally binding. Late payment penalties would be 2% of the unpaid child support the day after the due date and would go directly to the receiving parent unless they agree to waive them. If child support is more than 28 days late, then unlike IRD system, no further penalty would be added. Instead, parents return to mediation to address non-payment. This approach encourages flexible, personalised and culturally inclusive child support arrangements built around the real needs of the child and family. Our second reform proposal is to introduce a child support credit system which allows paying parents to receive credit toward their formal child support obligations when they make direct payments for approved expenses like school fees, medical bills or extracurriculars. Credit would only apply if clearly documented and either mutually agreed on or approved through mediation or a legal process. This model draws from Australia's non-agency payment system, which allows certain direct payments to count as child support even without the receiving parent's agreement in specific situations. In Australia, up to 30% of a parent's regular child support obligation can be offset through approved non-agency payments, with the remaining 70% still paid through the regular system. This credit is applied gradually until the full value of the direct payment is used. This offers partial relief to parents who cover major costs while ensuring continued support for daily expenses. Our model would differ slightly by integrating the system with our first reform. The credit system would be explained in the compulsory education courses and discussed during mediation, so parents can decide whether to incorporate it into their agreement. Like Australia, we propose a default 30% cap on credits, but allow parents and a mediator to agree on a different percentage if appropriate. Overall, this reform promotes fairness, supports co-parenting and encourages meaningful financial contributions that genuinely benefit the child.
Now, Minister, I draw your attention to some real-life examples of how our proposed reforms would work in practice. Moana and Lucy adopted Sam during their marriage. After their separation, Sam spends equal time with both parents. Lucy earns $81,000 a year, Moana earns $53,000 and applied for a formula-based child support assessment. Under the current system, Lucy pays just under $188 per month, but neither parent understands how that amount was calculated. Lucy believes the amount is too high given that she pays for many of Sam's daily expenses and has taken on an unexpected mortgage. The lack of clarity leads to ongoing conflict, affecting Sam emotionally. When Lucy misses a payment, an 8% penalty is applied after 28 days, further escalating tension and financial strain. Under the proposed reform, Moana and Lucy attend education and mediation sessions. This process helps them reach a fairer, more transparent agreement. They settle on $110 per month based on shared expenses and family contributions, namely care from Lucy's mother. They commit to reviewing the arrangement after 6 months. The 2% fee Lucy incurs is paid directly to Moana in recognition of the financial strain caused. If not paid after 28 days, they will be asked to attend further mediation, where they will have the opportunity to discuss their current plan and reevaluate accordingly. As a result, both parents feel more supported and in control. Sam benefits from a more stable living environment with less conflict and more consistency. Eva and Taylor co-parent their 8-year-old daughter, Lola. Eva cares for her 5 nights a week and Taylor for the remaining 2. Taylor earns $83,000, Eva earns $62,000. Taylor currently pays $413.90 a month in child support. Recently, Taylor brought Lola a new school uniform. While necessary, this expense is not recognised under the current system, and Eva refuses to contribute. Taylor feels unacknowledged for this expense and faces financial strain. He cancels a planned outing with Lola, who feels disappointed and confused. Frustration builds between the parents and Taylor becomes less inclined to help outside the formal system. Under the proposed reform, mediation confirms that the uniform expense was both valid and child-focused. With proof of purchase, Taylor's support obligation is reduced by 30% in the following months until the credit is accounted for. Eva continues to receive stable support while Taylor is recognised for his additional contribution. The added flexibility allows him to maintain meaningful time with Lola, improving their bond and reducing tension. This more responsive system supports both parents in managing real costs while keeping the child's well-being at the centre. Lola feels supported by both parents. Taylor is more willing to contribute voluntarily in the future, and Eva feels financially secure under a fair and cooperative arrangement.